Today's topic is legal remedies for violence against women. Introduction. Throughout the world, millions of women live in the conditions of abject deprivation and attacks against their fundamental human rights for no reason other than that they are women. Either in domestic sphere or outside, women from all walks of life have been criminally exploited. Women who constitute half the world's population and without whose presence the survival of the world would have been impossible, have ironically been made a subject of sexual exploitation and are suffering in this male-dominated world. Violence against women is a manifestation which have led to unequal power relations between men and women, and these have led to domination over and discrimination against women by men, thereby resulting to the prevention of the full advancement of women. Violence against women and girls continues to be a global epidemic that kills, tortures, and maims physically, psychologically, sexually, and economically. It is one of the most perversion of human rights violation, denying women and girls equality, security, dignity, self-worth, and their right to enjoy fundamental freedom. No society can claim to be free of such violence. The only variation is in the patterns and trends that exist in countries and regions. Specific groups are most vulnerable, including minority groups, indigenous and migrant women, refugee women, and those in situation of armed conflict, women in institutions and detention, women with disabilities, female children, and elderly women. International law and violence against women. Ever since the inception of United Nations till date, the UN has worked to secure women's legal equality. Commission on the Status of Women 1946 was formed to uplift and develop the status of women in education, political, social status, etc., followed by the Universal Declaration on Human Rights 1948, Convention on the Political Rights of Women 1953, Declaration on Elimination of Discrimination Against Women 1967, Convention on Elimination of All Forms of Discrimination Against Women 1979. The most comprehensive policy of statements with reference to gender-based violence have been the Declaration on the Elimination of Violence Against Women adopted by the United Nations General Assembly in 1993 and the Platform for Action 1995. Both these documents define gender-based violence as a violence of women's human rights and a form of discrimination that prevents women from participating fully and effectively in the society and fulfilling their potentials as human beings. The Vienna Declaration 1993 and the Platform for Action declared that the UN should work towards eliminating violence against women in public and private life, all forms of sexual harassment, exploitation, and trafficking in women, gender bias in the administration of justice, and any conflicts arising between the rights of women and the harmful effects of certain traditional practices, culture, prejudices, and religious extremism. In 1992, the Committee on the Elimination of Discrimination Against Women adopted General Recommendation 19, in which it confirmed that violence against women constitutes a violation of human rights, emphasizes that State may also be responsible for private acts if they fail to act with due diligence to prevent violation of rights or to investigate and punish acts of violence and for promoting compensation. The Commission on the Human Resources in April 1997 emphasized that the government must not commit any act of violence against women and must prevent, invest and punish acts of violence against women by the state. India, being a signatory to the various international conventions and protocols on human rights, was assumed the responsibility to provide and protect rights of the women, and as such, it confers a katana of rights upon women. India's position. Despite implementation of human rights treaties, severe punitive approach of criminal laws, constant monitoring of National Human Rights Commission, untiring efforts of women organizations and the National Commission for Women to liberate women from the unjust political and economic subjugation and suppression, they are being sexually exploited, abused and assaulted, resulting in violence of human rights. Sometimes the protection of the law and order, taking advantage of their position, turn into offenders and commit rape and other atrocities against helpless women, either in their custody or otherwise. Constitutional remedies. Criminal jurisprudence has moved beyond the traditional domains of retributive and deterrent values. The shifts are increasingly towards victim-centric compensatory model of justice. The concept of a publicly funded and administered body to compensate victims of violent crime has been in practice in many countries across the world. It is granted not merely when the state is at fault, but also when the crime is violent and serious. It becomes the duty of the state not only to prosecute the offender, but also it is the liability of the state to compensate and rehabilitate the victims of the crimes. Mere sentencing would not meet the ends of justice unless victim is suitably compensated. Keeping in view the provisions enshrined in Article 9 of the International Covenant on Civil and Political Rights 1966 and other international instruments, the Supreme Court in a number of cases awarded monetary compensation where there has been violation of constitutional right of the citizen. Right from Rudal Saha versus State of Bihar 1983 for SCC 677, People's Union for Democratic Rights versus Police Commissioner, Delhi Police Headquarters 1989, Volume 4, Supreme Court Cases 730, etc. The Supreme Court, by invoking the inherent power, ordered for payment of compensation to the victims. The Supreme Court in Delhi Domestic Working Women's Forum versus Union of India 1995, Volume 1, Supreme Court Cases, page number 14, has indicated broad parameters in assisting the victims of rape. Following are some of the parameters set forth by the Supreme Court. In all rape trials, anonymity of the victim must be maintained as far as necessary. It is necessary, having regard to the directive principle contained under Article 38, Clause 1 of the Indian Constitution, to set up Criminal Injuries Compensation Board (CICB). Rape victims frequently incur substantial financial loss. Some, for example, are too traumatized to continue in employment. Compensation of the victims shall be awarded by the court on conviction of the offender and by the CICB, whether or not a conviction has taken place. The board will take into account pain, sufferings and shock as well as loss of earnings due to pregnancy and the expenses of childbirth if these occurred as a result of the rape. In Chairman, Railway Board versus Chandrima Das, AIR 2000 SC, page number 998. A practicing advocate of the Calcutta High Court filed a petition against various railway authorities claiming compensation for the victim, a Bangladeshi national who was gang raped by many, including employees of the railways, in a room of Yatri Niwas at Howrah station. The High Court awarded Rs 10 lakhs as compensation. The Supreme Court observed that rape amounts to violation of the fundamental rights guaranteed to a woman under Article 21 of the Constitution of India. Foreign citizens are also a constitutional liability to pay compensation where rape is committed by the employees of the government abusing their authority. In 2005, the National Commission for Women set a draft scheme to the central government, and the Committee of Secretaries gave the following guidelines. Number 1, that the plan scheme would be prepared by the National Commission for Women, Department of Women and Child Development for disbursing compensation to the victims of rape, and the scheme should also provide for interim compensation. Number 2, the quantum of compensation is to be worked out by the Department of Women and Child Department in consultation with the National Commission for Women. Number 3, provision for budgetary requirement for the scheme, which would be transferred to the states as grant in aid. Number 4, setting up of district level committees headed by the magistrate to consider the claims. Number 5, Criminal Inquiries Compensation Board to monitor the implementation of the scheme by the state government and attending to any complaint received in this regard. Number 6, the Ministry of Home Affairs would issue suitable directives to state government for directing the public prosecutors to plead before the competent court to award suitable compensation to the victims. Number 7, monitoring of the scheme by the National Commission for Women. Accordingly, the Supreme Court and the High Courts awarded compensation to victims in a number of cases. Statutory remedies. Crimes against women have been classified under the Indian Penal Code 1860 and special laws such as Immoral Traffic Protection Act 1961, Indecent Representation of Women Prohibition Act 1986, Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989, Prenatal Diagnostic Technique Regulation and Prevention of Misuse Act 1994, Information Technology Act 2000, Protection of Women from Domestic Violence Act 2005, and the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. The Indian Penal Code makes disclosure of identity of victim of certain offences punishable. Printing or publishing name of any matter which may make known the identity of any person against whom an offence under section 376, 376A, 376B, 376C and 376D of the IPC is alleged or found to have been committed can be punished. Under the Code of Criminal Procedure Amendment Act 2008, a new proviso to Section 157 provides important safeguards to the victim of rape. The proceedings for sexual offences are now required to be held as far as practicable by a court presided over by a woman. Under Section 22 of the Protection of Women from Domestic Violence Act 2005, the magistrate may pass an order directing the respondent to pay compensation and damages for the injuries, including mental torture and emotional distress caused by the acts of domestic violence committed by the respondent. This is in addition to other reliefs provided in this Act. Moreover, the provisions are absolutely independent and are in addition to any other remedy available to the aggrieved under any legal proceeding before the Civil, Criminal Code or Family Code. Section 13, Clause 3, Subclause 11 of the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013 provides for payment of compensation to the aggrieved woman or to her legal heir for the mental trauma, pain, suffering and emotional distress lost in the career opportunity due to the incident of sexual harassment, medical expenses, etc. It may also be pertinent to mention herein that Section 357A of the Code of Criminal Procedure Amendment Act 2008 incorporates a newly introduced victim compensation scheme to alleviate the suffering of the victim and to provide important safeguard to their rights. For any offences committed to the women under the Indian Penal Code and other special acts, Section 357A CRPC is made applicable. Conclusion. A recent study has concluded that violence against women is the fastest growing crime in India. According to the latest report prepared by India's National Crime Record Bureau, a crime has been recorded against women every 3 minutes in India. Every 60 minutes, 2 women are raped in India. Every 6 hours, a young married woman is found beaten to death, burnt or driven to suicide, and one case of cruelty committed by either the husband or relative of the victim occurs every 9 minutes. In addition to this, the problem of sexual harassment at the workplace has assumed serious proportion with a meteoric rise in the number of cases. Surprisingly, however, in most cases, women do not report the matter to the concerned authorities. Women should strive for the betterment of her condition with her own efforts, and this can happen only when she recognizes her power and energy which spins the whole world. Women should come out of those walls which have suppressed them for ages and prove that they are no less than men. Thank you.